Today, we're going to dive deeper into the art of cross-examination.
Cross, Mr. Adams?
Please.
All right, go right ahead, sir.
We're about to heat them up. The step back from the mic is sending me. You know you're finna get ate up when the attorney step back from the mic like this.
Oh, yes, sir. Go ahead right in. I'm sorry.
Thank you. Captain, that's good afternoon, sir. How are you?
Good afternoon. I'm doing well. Thank you.
All right. You and I have had a chance to chat before. Sure.
Yes.
All right. So I represent the police from the city of Glen Black, Law, Mississippi. But I do want to ask you some questions about this gentleman that you arrested, Mr. Trontavious Stevens, and the incident surrounding him. Okay.
Okay.
You were an APD officer back in 2013, yes?
Yes.
All right, so let's start off by talking about what cross-examination is. As most people know, on cross-examination, you can ask leading questions, whereas on direct examination, you cannot. For example, a leading question is, you were an officer in 2013, correct? You're leading them to say the right answer, which is, yes, I was an officer in 2013, that's correct. Versus, when did you first start working as a police officer? You're not having the answer in the question. You're not leading them to an answer, right? If you say, when did you start becoming a police officer? They're gonna have to remember and answer, of their own accord. This is because when you're on direct examination, particularly when it's the state, right, trying to direct examine a witness, rather, it's not right for them to be able to lead that witness into saying, the correct things and answer correctly by law. That's just not what you're supposed to do. So that is a difference between a question on direct examination and a question on cross-examination. And what you're going to see here is the attorney cross-examining, so leading questions and asking leading questions a lot.
You arrived at the location that we've been discussing at about 4:30 in the afternoon. Sure.
If that's what the report says, yes.
And I know we've spent some time with the report. Yeah. In front of you?
I do not.
All right. Matt?
Yes.
Yes.
Just please identify for the record, please. What?
Thank you, Judge.
Okay.
Judge, I'm going to, with the court's permission, approach the witness and show him what's been previously identified as states 50 Alpha 50A.
So what he's doing here is he's walking up to the police officer and providing the police officer with the police report that the officer wrote back in 2013. The state has already admitted this exhibit into evidence, so the defense attorney is going to be able to show the officer here, without going into crazy detail, the police report without objection from the state or from anybody else.
Okay, it's been admitted, so yes, that's fine.
All right, thank you, Judge. That's your report, right, Captain?
Yes, sir.
That's a report you prepared back in January 2013, right?
Yes, that's right.
What's that, about 15 pages long, that report?
The report itself is actually only 2 pages. What's attached here is the warrant application, another copy of the report, and the actual warrants, along with the copies of the arrest tickets.
So when you get a packet, an arrest packet, right? A lot of times it'll contain the police report, but also the warrants. Sometimes it might have another copy of the police report, things that were taken in property, all these other forms attached in paperwork attached to the police report. So what the officer is saying here is that there's 15 pages worth of stuff, but only 2 pages consist of the actual narrative, the police report.
All right, the report itself that you wrote about 2 pages, right?
Yes, sir.
But it fairly and accurately captures what happened on that day and your involvement in everything that happened. Is that true?
Yes.
Okay. Just to be clear, you were not involved and you don't know anything personally about how this vehicle that you saw came to be taken, right?
Correct.
I mean, you were aware at some point that this is something that happened over Newton, right?
I would have to look at the report to tell you what jurisdiction it was stolen from.
Because you don't know personally.
Correct.
And then you don't know where the car was, who was in possession of it.
So long story short, the testimony earlier was that there was a carjacking that took place in Noonan. This officer at some point thereafter came into contact with the stolen vehicle, but the officer doesn't know who stole the vehicle, how it got to where he was at. He doesn't know any of that. He just pulled into a neighborhood without a cop car and in plain clothes, and he encountered these people who the officer is alleging, who's saying now in 2023 that these were gang members. So that's a little bit of context as to why the defense attorney is asking these questions.
Or how it came to end up in this apartment complex where you saw it, right? Yes. You don't know who, David Stevens, anybody else was ever in possession of that vehicle prior to the day that you showed up in that apartment complex. Is that true?
Yes.
Okay. Now, I want to jump ahead a little bit and then come back. Because what I want to make sure I'm clear on is that what you actually ended up arresting Trontavia Stevens for was aggravated assault, right?
That was one of the charges.
Aggravated assault because Quantavia Stevens, as the officer is alleging, pointed a weapon at the officer while the officer was in a vehicle.
The other one was pointing or aiming a pistol at another, and the last was the warrant that he had.
Okay. Essentially, the officer who was involved, who was the crux of this case, what you charged the
Objection, Your Honor, as to the testimony about crux of the case that Mr.
What's your objection, madam? Is it form? Is it, what is
Form
it?
is testifying.
I'll sustain as to form. Just rephrase, Mr. Adams. Okay, all right.
You were the officer who took out the charge, right?
Yes.
You are the person that's listed as the victim in this case, right?
Yes.
The officer is listed as the victim in the aggravated assault, as I was saying earlier, because Quantavia Stevens, the officer alleges, pointed a gun at the officer. So this officer was also the same person who took out the charges, took out the warrants, because obviously he was a law enforcement officer, so he can do that. So he's both the victim and the officer who is technically pressing charges. So it's interesting.
And the criminal offense that you charged Mr. Trontavia Stevens with was aggravated assault, right?
Yes.
You didn't charge him with auto theft, right?
Correct.
You didn't charge him with carjacking, right?
Correct.
Because you had no evidence that he did any criminal act other than what you said was an aggravated assault, right?
Correct.
Okay. In fact, what happened here, I'm jump back now, is that you get to the apartment complex because you advised over radio that a stolen vehicle is located in this area, right?
Yes.
Okay. You get there, you are in plain clothes.
Yes.
If you don't have a uniform on, you're dressed regularly.
Correct.
Your partner, Officer Ramirez, also in plain clothes.
Correct.
Dressed regularly, no uniform, nothing like that.
Right.
You're in an unmarked car, right?
Yes.
No police markings on the car, nothing that identified it as a police car, right?
Correct.
Anyone looking at the vehicle would see a regular car with two regular looking folks inside the car, right?
Yes.
Okay. You pull up, and the car that we're talking about is parked there in location, and you guys sit on it.
Correct.
About 45 minutes.
Yes.
At some point, you all don't know what happened to it because you saw it coming back your way.
Right.
Which suggests obviously that it left without you knowing that it left, right?
Right.
Okay. Comes back and it backs into a parking spot.
Yes.
Okay. A person gets out of that car and that person starts to walk towards apartment number 7 that you referenced, right?
Yes.
Now, that person, from your observation, you're inside the car and your windows are rolled up, right?
Yeah. Yes.
And you move towards where the car had backed in. True?
Yes.
All right. You're now 10 feet away from this car, maybe from here to about there, right?
Yes. Yes. 10 feet.
Windows still rolled up, plain clothes inside the car, and some people come out from apartment number 7.
Yes.
All right. Now, Trontavia Stevens, the person that we're talking about, who ends up the person with the gun, the guy you arrested, he is not the same person who had gotten out of that car.
Correct.
In fact, at no point in this day did you see him interact with that car at all.
Correct.
Right.
Right. And this is important because number one, I want to bring up the fact that, like I said earlier, and I hope I explained this attorney right now is not the attorney for Quantavious Stevens, but he's going to have to address this because the state is trying to tie all this back to gang activity, which ties back to Young Thug. So if they can break down this allegation of gang activity, if they can break down this connection between number one, Quantavious and gang activity, but number two, gang activity and Thug, then that's going to be better for their case. So that's why he's trying to break this down right now. It's also important to know that, again, this is all relating back to this carjacking that they're trying to relate back to gang activity, but the state heretofore at this point, right, has not demonstrated that this Quantavious individual carjacked the vehicle or was even in the vehicle. It sounds like Quantavious came out of the apartment where the vehicle was located in that apartment complex, right? But we don't even know if the car was parked because it was, from apartment number 7. We don't know any of that information. All we know at this point is that there was a car in the vicinity of a door where Quantavious came out. So that's what we have at this point.
What you saw was him and other people coming towards your unmarked police car with the windows rolled up with regular dressed individuals inside, and you saw them motioning to roll down the window, right?
Right.
And you said they appeared to be aggressive.
Yes.
In fact, one of the words you used is that, I think you said, Quantavious Stevens appeared to be the most violent in his actions, right?
Yes.
Now, when you testified a while ago for the state, they asked you a couple of questions about this. You said they were flashing gang signs, right?
Correct.
Now, you didn't say that in your report, did you?
No.
And I mean, you wrote a 2-page report, and it was very detailed about everything that happened and everyone who was involved, down to names and dates of births, right?
Right.
You put a serial number in there, right?
Yes.
And you're trained as a police officer that anything that is of significance, like if you think, for example, something is gang related, you put that in the report, right?
Right.
But that report, the same one that she had you read, right, because you can remember some stuff. In that third paragraph where it talks about what you saw those people doing, you ain't say nothing about, I saw gang signs, right?
Correct.
Oh, here we go. What a classic line of questioning, when a police officer conveniently leaves something out of their police report. Here, today on the stand, the officer said that he saw what he believed to be a gang sign being thrown up by Quantavious Stevens or, some of the other individuals that came out towards his vehicle, his unmarked police vehicle. But what the attorney is bringing out is that was nowhere in the police report. And the police report is 2 pages long. It's pretty detailed. You got serial numbers. You got dates of birth. You got all these other details in there. And you would think something important such as gang activity, gang signs, right? Some connection to a gang would be listed in that police report, but it's not listed in the police report. And that is what the defense attorney is drawing out here, casting doubt upon the testimony, the credibility, the memory of the officer. So this was a really classic, excellent line of questioning and cross-examination.
What you said was that the person who would later be identified as Quantavious Stevens, and again, I'll represent that here, but what you said is that he was moving towards your car, right?
Right.
Motioning to roll the window down, right?
Right.
And then you never did. You didn't roll the window down.
I don't think so.
Okay, what was the attended?
I don't know.
You remember?
No, sir.
All right. You saw him motion towards his waistband or grab a gun that was in his waistband. That's what you said, right?
Yeah.
And held it down like below his waist and pointed at you and your partner.
Correct.
Kind of like this, all right?
Yes.
That is the element of the aggravated assault that you saw and that you ultimately charged him with.
Yes.
You drove off at that point.
Yes.
Right? Wasn't any shooting or anything like that. You drove off and you called for either backup or what do you call it, a takedown team?
Yes.
Okay. Right. So that was the problem, the assault, right?
Correct.
So you show up, takedown team for one other car, a bunch of cars.
I don't remember the exact amount.
Would it be fair to say that within a relatively short period of time, there were cops crawling all over that location?
I don't think that would be a fair assessment. No, sir.
APD showed up, right? Other APD officers showed up, right?
Yes.
Okay, so what you saw there was, it's not super important to get the officer to be pinned down on, when the APD team came out, the officer didn't want to coalesce or didn't want to say, yeah, they were there in a short amount of time. I don't know. I guess he was saying that's not accurate. So what you saw was the defense attorney kind of reroute him back towards, okay, just focusing. At some point, APD showed up. So that was a good way to deal with the witness who was not giving you the answer that you want them to give, but going off of what the witness gave you, right? Being flexible and going where the witness is going, but still trying to corral them back to what you want to talk about and the questions that you want to ask.
At some point, Georgia State Patrol was involved in this incident, correct?
Yes.
At some point, Norfolk Railroad Police were involved in this incident, correct?
Yes.
Okay. A couple of different jurisdictions of police.
Yes.
Police went to the apartment number 7, right, and ended up getting those people out of the apartment, right?
Yes.
Police followed the Buick that Mr. Stevens was in for some period of time down to the gas station, ended up getting those people out of the Buick, right?
Yes.
And you recovered a gun.
Yes.
Okay, well, not you personally, but a gun was recovered.
Yes.
That you would later say, yeah, looks like the gun that, that kid had, that you wanted it.
I was personally involved in the recovery.
Okay.
Yes, sir.
All right. It was something like that, right?
Yes.
Not question, Judge?
You may, sir.
Okay, what you see is he's about to show the officer another exhibit, one of the exhibits that the state has already tendered and gotten into evidence. And so the defense attorney is looking through there to show the witness one of the exhibits.
No, states
50, is it? No, what's that?
2A. This is not prosecutor Twin.
Yes, sir. And 3, is it just 2A?
Is it 2A and 3A, sir?
Yes, sir.
He's on one.
Yeah, it's 2A and 3A.
All right, thank you.
Okay.
This gun, right?
Yes.
Found in this bucket.
Yes.
Okay. So, a question or two about descriptions. The person who was in the car, who got out of the car, that you referenced, was wearing black.
Yes.
Black do-rag or something like that?
Yes.
Black shirt or hoodie or something like that?
Basically all black.
Okay. Truncated Stevens is a guy, he had a whole lot of hair, right? Like
I have no idea.
you all remember?
No, sir.
All right. All right.
And that's pretty standard, right? In a case that happened in 2013, a case that happened in 2018, 2020, 2022, sometimes you'll get an officer on the stand. There's going to be a whole lot of, I don't know, I don't remember, because, either they don't know, they don't remember, they don't want to say, who knows? But it is typical to get, I don't know, I don't remember from officers testifying in cases like this, which can be frustrating, but it's something that you're going to have to come up against if you decide to be a trial lawyer.
The time that this incident occurred back in 2013, you had been an officer at APD for how long?
I got hired November 14th, 2006.
All right. By that time, you had received what I think I heard you say was some training in regards to gangs and gang recognition and stuff like that, right?
Yes.
All right. You were trained and you were told that if there is an incident that occurred and you believe it to be gang related or anything like that, that you indicate that on the police report.
Probably.
Okay. You didn't indicate that anywhere on this police report that there was any sort of gang involvement in this case, did you?
No.
All right.
Okay, so that line of questioning was excellent, obviously, because if you're an officer and you're trained not only in regular crime, but specifically in gang activity, and you've been to trainings and they've told you to write down in your police report if you recognize anything relating to gang activity and you don't write it down, that does tend to show that you didn't see any gang activity. And so again, it's going to cast doubt on you saying that all of a sudden today, in trial or whenever you first brought this up, that you saw these gang signs. I'm going to question, why didn't you write that in your report if that's true?
If you thought that there was some sort of gang offense committed,
Objection calls for speculation.
Let's stand this if you rephrase, sir.
Okay. You didn't charge him with any gang offense.
No, sir.
You didn't charge anybody with any gang offense on that day, right?
Correct.
All right.
So this is really important because again, he's trying to bring up the fact that nobody was charged with gang, offenses, gang charges, nothing gang related. And all of a sudden you're here today in this RICO trial testifying about gang activity.
Ten seconds if you don't mind, Judge.
Not a problem, sir.
Maybe a little more. I think I heard you say earlier, or did I hear you say earlier?
This is killing me. But when the glasses come off, ooh, I'm obsessed. Let me just say, I love this so much. I love the step back from the mic, the glasses come off, the pen tap. I don't know. It's just, don't you love it when a trial comes together?
That one of the things that they were looking for in apartment 7 were keys to the stolen vehicle.
Yes, sir.
You weren't in the keys found, right?
No.
Nowhere, anywhere on the premises, on location, outside, in the car, in the blue car, nowhere, no keys found.
Correct.
Okay. That's all I got. Thank you.
Any further?
Okay, so to wrap up, he was talking about keys to the vehicle, the stolen vehicle. So Quantavious Stevens comes out of apartment number 7. He doesn't go near the vehicle that was marked stolen. Officer has never seen Quantavious Stevens get out or go into that vehicle. They search the home in which Quantavious Stevens was in, and they don't find the keys to the stolen vehicle. So the question is, how is the state, first of all, tying Quantavious Stevens to the gang activity, then to Thug? Number 2, tying Quantavious Stevens to this stolen vehicle, and then to Thug. Like, there's gaps. I'm listening. I'm waiting for the state to wrap it up, bring it all together. Maybe that's going to happen down the road. Maybe we won't even hear that until closing statements. But that is those weaknesses, those plot points, as I'm gonna call them, those holes are what the defense attorney is bringing out right now. And if you need a defense attorney, I'm a defense attorney in Atlanta, Georgia. I represent people in all types of criminal cases. I also represent people for personal injury cases. So that means car accidents. If you've got a little fender bender or got hit by a truck, please contact me at the link below, and we'll join you next week when we continue on with this trial coverage. Love y'all. Thanks for tuning in.